thank you for your patience. We covered from that last session. This is the Forum for Law, Ethics, and Society, and for those of you who aren't in the class, I want to welcome you if anyone is interested in learning more about the study of pre-law and ethics here at Sonoma State, or interested in the Center for Ethics, Law, and Society. I have some lovely reading material, so just come on up afterwards. We hopefully will have a couple of minutes for Q&A. I also got the questions from those of you who posted them on the Moodle forum, so that was nice. Everyone worked off well on that front. Okay, so let me introduce today's speaker. This is Sinrod. He's a partner in the firm Duane, which not everyone knows, but is one of the largest, most prestigious firms in the country, in the world, in fact. He does trial, appellate, and litigation work. He's argued before the Supreme Court. He is, his specialties are in internet software, tech, and intellectual property law, information communications, antitrust. He has been named the leading, let's put this up here, the leading IP attorney in the land. He's been named one of the best lawyers in America. He also holds one of my favorite titles I've seen yet, of super lawyer. Sort of the heroic status. And as you can see there, he's written for a pretty impressive roster of publications like the Wall Street Journal and the New York Times. So we are very privileged to have Mr. Sinrod here today. And the title of his talk, to go back, is Risks and Liabilities in Cyberspace. So please join me in welcoming Eric Sinrod.
Your applause. Hopefully you'll applaud at the end. That's when it counts. Okay, my job is to keep you interested and awake, and I hope to do that. So that's me. From the picture's a little bit dated. Hopefully I still look like that a little bit. By the way, I write a weekly cyber law blog. You've been informed about that. If you want to subscribe to it and get it in your email box every Thursday, just send me an email putting subscribe in the subject line to that email address, and once a week you will get an email on issues relating to the intersection of law and technology. And if you get them and you don't like them, then you can unsubscribe. Don't worry, your email address is safe. We're not sharing or selling your information. Okay, so we're going to talk about some interesting topics today, where the law and technology intersect. And right now we're going to talk about domain names. You all know what a domain name is, right? That's essentially your address on the internet. So my law firm, for example, is DuaneMorris.com. An automobile company might be Ford.com, or Apple.com is a computer company. So why do I have these letters FCUK on the screen here? Well, on the screen here too. Surround sound, surround video. Because there are trademark issues that come up in cyberspace. So what's a trademark? A trademark is sort of how you brand your company or your goods and services, right? So who knows what FCUK stands for? Anybody? French Connection United Kingdom. Anybody heard of French Connection United Kingdom? What is French Connection United Kingdom? Yeah, it's a clothing company. They were originated in England, and they were selling clothes. And they were just one of many clothing companies. And then all of a sudden, they decided to take off on their trademark, FCUK. Why? Because it's provocative. Look at those letters. You might, when you do that, you might think of something else. I won't say it, but you might think of something else. And all of a sudden, they started branding with FCUK, and guess what? They became a global clothing company because it gets your attention, right? Now, on the internet, you can't register a domain name using those letters by flipping the U and the C. Why? Because it's deemed obscene. You can't register domain names that are considered obscene. You can't use the FU. You have to do FC. So what happens is a number of sort of knockoff websites have shown up using my client, I represent French Connection United Kingdom, using their trademark, FCUK. Now our company doesn't like that because it's their branding and they want to control their image, right? So what happens is, it's my job, for example, to police the internet and see if another company is using FCUK in its domain name. Like, for example, there was a company that went by the domain name FCUKLifestyle.com. And if you went to FCUKLifestyle.com, what do you think you found there? Pornographic content, right? Somebody was speaking up, I interrupted.
Explicit content?
Yeah, you got it, explicit content. Now, French Connection United Kingdom doesn't like that for a number of reasons, including the fact that it tarnishes their image. Now, my client's selling clothing, they're not selling pornography. So what happens is a lawyer like me writes a letter to somebody who registers a domain name like that and says, by the way, dear person, even though, yes, you went to an internet registrar and were able to register that domain name, it doesn't mean you're allowed to keep it because you've incorporated our client's trademark in your domain name. You need to turn that over to us. Now, most people getting a letter from a law firm saying that will go, gosh, sorry, I didn't realize that. I didn't know about trademark law. Okay, leave me alone. Here's the domain name. But sometimes they want to fight about it, and then we have a choice. We either go to federal court under the Anti-Cyberspace and Consumer Protection Act. Can anybody say that? Anybody say that fast 10 times? I don't know if you can. But under that statute, it's a federal statute. If you go after somebody who's registered a domain name with your trademark and you win, you get the trademark, domain name, you get damages, attorney's fees, statutory damages, and punitive damages. It's a big deal. But most of the time we don't go to federal court because usually the people that are registering these domain names really don't have much money anyway. And so one thing you'll learn if you start studying law, you know, it's great, you can win a lawsuit. It's not so great if you win and you can't collect anything. If the person is judgment-free, they basically have no money. So normally what we do is we go to arbitration under these World Intellectual Property Organization arbitration rules and just do a quick arbitration on the papers, and most of the time we recover the domain names. Okay, who's heard of Madonna? Right, everybody's heard of Madonna. Madonna's my age and she's still rocking, so I like her at least for that much. I'm not sure I like her music so much. That's a mistake, by the way. It should say Madonna.com. So we're dealing with another domain name. So Madonna, believe it or not, has obtained a federal trademark in the term Madonna. Why is that surprising? What? It's a name. Yeah. What else? She's not uniquely Madonna. There are actually hundreds of people in the world today named Madonna. It's also a name of historical and religious significance. If you go to art galleries in Europe, you will see paintings of like the Madonna on the rocks from like 500 years ago. So Madonna Ciccione, which is a real name, she's from Michigan, by the way, where I went to law school, University of Michigan. She actually studied dance at the University of Michigan. Not that that's too relevant to you. She nevertheless convinced the Patent and Trademark Office to give her a trademark in that name. And then along comes a website, Madonna.com, and what do you think is on that website? Same answer as the fellow in the back page before. Explicit adult-oriented content. So Madonna hired lawyers to go after that website saying, look, I've got a trademark in the name Madonna. You can't have a website, Madonna.com, and by the way, you're tarnishing my image with your pornographic website. Now, why is that a weird argument?
It's just a name.
Yeah, what else? How has Madonna marketed herself? She's marketed her sexuality. She wrote a book called Sex. What do you think's in that book? Pictures of herself. And her whole image is one of sexuality. So it's a little odd that she's complaining that a porn site is tarnishing her image. So, what happens? The porn site has a choice. They can either fight with Madonna and all of her attorneys, they can just give up and give her the domain name, Madonna.com, or they can do something else. A, B, or C. Take a wild guess. C is a good guess in this class because it's more interesting. Something else is always more interesting, right? There's some default answers in this class. One is explicit content, another one is something else. The something else is the porn site transferred the domain name to the Madonna Rehabilitation Clinic of Kansas. Right. You're thinking, huh? What's going on here? There's a place in Kansas where if you're crippled, you're paralyzed, you got a broken back, you can go there and they will help you with your injuries. And they've been called the Madonna Rehabilitation Clinic of Kansas since long before she was even born. So now if you go to Madonna.com, and by the way, if you have laptops and stuff, don't look any of this stuff up because it just spoils the fun. But at this point, if you went to Madonna.com, you're not going to see porn anymore. You're just going to see a place that helps people in Kansas get better from their crippling injuries. Well, it's hard for her to argue that her image is being tarnished by those good works. There's also very little likelihood of consumer confusion, which is the ultimate test in trademark law. Will people be confused? If you went to Madonna.com at that point and saw a place in Kansas, a medical facility in Kansas, you wouldn't go, oh my God, is this sponsored by and relating to the singer Madonna? No, you would know it's distinct and different. So Madonna sues the Rehabilitation Clinic of Kansas, the Madonna Rehabilitation Clinic, saying I'm entitled to that domain name, Madonna.com, because I've got the trademark. And the Rehabilitation Clinic defends saying, yeah, but we are actually the Madonna Rehabilitation Clinic of Kansas. We've been called that forever. We're entitled to use the name. And by the way, every case example I'm going to give you here today is a close call. I'm not giving you the easy situation where somebody's walking across the crosswalk, somebody's drunk and plows into them. I mean, who's at fault? The driver. These are all close calls. And that's what I specialize in, close calls. It makes my practice really interesting. Who wins? Madonna or the clinic? Who gets Madonna.com?
I would say the clinic.
You would say the clinic?
Established.
Yeah, that's a good answer.
Madonna.
Do you say Madonna? Why?
Because law in this country is kind of like.
I don't know what that means. What's your
Madonna has the money and the lawyers.
What's your name?
Casey.
Casey gets a good gold star. Right. Okay, so there are morals of the stories that come up in this case, and that in this class, and that is, if you have money, it's a fact. You can buy a little bit more justice. You know, when you have a jump ball, right? If you can hire an army of attorneys like she can, you have a better chance of winning, whether it's fair or not. Okay? And that's what happened here. Casey's correct. Oh, look at little Veronica. Right? Anybody ever seen a baby before? This is a baby. And long before Facebook, you guys grew up on Facebook, right? But long before Facebook, there was a time, well, once upon a time, if you wanted to show people pictures of your kids, you actually had a photo album. That's what I grew up with. But then after that, if you wanted to show pictures to the internet, you actually registered domain names and created a website. It wasn't so easy as just having your own Facebook page or all the other stuff you guys do these days. Instagram, Snapchat. Okay? So there was a family, and they registered Veronica.org, so you could see their beautiful baby. They wanted their friends and family to see their baby. So far, so good, right? Veronica.org. Now, who's heard of Archie Comics? Right? Okay, Archie Comics. Who's heard of the character Veronica? Yeah, she's the pretty, dark-haired character, comic book character from Archie Comics. Guess what? Big surprise. Archie Comics has a trademark in the name Veronica for their cartoon character. What happens next? A big law firm sends a letter to this family saying, hey family, I think there's a pointer on here. Oh, isn't that special? Oh, that's not what I wanted. I'm not going to use that again. Hey family, nice website, beautiful baby, but you've got a problem. You're using our trademark in your domain name. And if you don't transfer that to us immediately, we're going after you under the Anti-Cyberspace Consumer Protection Act for all the damages I told you about earlier. What does the family do? Do they fight? Do they give up the name? Or do they do something else? Come on, you guys, wake up. What do they do? All together now. Something else. 1, 2, 3. Something else. Good, you're awake. I appreciate that. Right. They hold a press conference. Very clever. They don't want to do this in the court of law. They want to do this in the court of public opinion, which makes a big difference in this country, okay? So they sit behind a table. I'll do my best imitation of being a family. Forgive me. This will be bad. Hi, I'm Dad. Hi, I'm Mom. This is our baby Veronica. This terrible company is trying to sue us for our website. Anyway, long story short, they explained in this press conference that they're just a family. They're not competing with Archie Comics. They don't have a rival comic book. They're not going to create any likelihood of consumer confusion. If you go to Veronica.org, you're not going to think, oh my gosh, this has to do with Archie Comics. There were several of you up here who know about Archie Comics. Did any one of you think this baby was related to Archie Comics? Hell no. Right? You didn't. So, what happens? Archie Comics has big time egg in its face. And they go, oops, sorry, didn't mean it. Go on with peace, family. You can keep your domain name, even though it has our trademark in it. Couple lessons here. One lesson is, if you're ever a lawyer and you're advising a client, even if you have what's called a colorable claim, that means you have a claim that has potential merit, think about the practical effect of what you're doing. And secondly, never, ever mess with babies. Babies always win in lawsuits. It's a fact. 30 years of practice tells me you don't. Yes, sir.
I was wondering though, just like that, where the company allowed the
Speak up a little louder.
so the family allowed the company allowed the family to have their name. Is there ever cases where the company will allow the people to keep that name but pay, in order to keep it, as long as it's not explicit or
Yes.
damaging?
Yes, so there can be situations where you can have financial arrangements where you're sort of buying and selling and allowing domain names. That's your question. Yes, that does happen. So good question. What was your name?
Taylor.
Taylor, good question. Okay, now we're dealing with sucks sites. Don't let your imaginations run, okay? This is about, well, who knows what a sucks site is? This is a complaint website, okay? So I need somebody here to volunteer to be somebody who's unhappy with their experience at Kentucky Fried Chicken. And this, by the way, is a hypothetical, so this is not a real, this is not a real, a lot of cases here are real. What is your name, sir?
Nick.
Nick?
Yeah.
Nick, okay. So Nick's a regular guy, and he's hungry. And he goes to Kentucky Fried Chicken for a meal. And he walks in, and the floor's kind of slippery with grease, and he falls down and breaks his back. That's bad. Not only that, Nick's mom works at Kentucky Fried Chicken, and she works 20 hours a day and isn't paid overtime. Right? That's bad 2. And then bad 3 is that when Nick gets up with his injured back and pulls up his bucket of fried meat, he's expecting to be eating fried poultry. Am I correct? And when he looks in that bucket, he's eating fried rat. Nick's mad. For 3 reasons, right? Wouldn't you be mad? I'd be mad. So Nick registers a sucks website. KFCsucks.com. And as I said, this is all hypothetical. This is not a true story. Well, what does he put on his website? He puts on there about how he broke his back and his mom's not paid overtime and how when he was eating what he thought was fried poultry, it was fried rodent. And he puts it up on the web and it goes viral. It gets, 1 million views. And what happens to Kentucky Fried Chicken?
Face a lot of heat.
Huh?
They face a lot of heat.
A lot of heat in the kitchen. Yeah. And not only that, people are less interested in going to eat there. And over the next couple weeks, they have 50% drop off in people buying their food. Their share price plummets. Huge financial implications. So Kentucky Fried Chicken, with its army of attorneys, goes after Nick and goes after his website. Okay? First thing they argue is, hey, you put KFC in your domain name. That's our trademark. Are you allowed to do that?
Yes.
Well, don't give up that easily.
Yes.
No, yeah.
What's your friend's name? What's your name?
Simon?
Simon. Is he allowed to use it?
Yes.
Tell me why.
Because he first broke his back.
That's true.
He did get damaged physically,
Yeah.
probably mentally from KFC. Seeing that instead of being chicken, he's seeing rat. So he's probably being traumatized.
Yes.
He's traumatized probably physically and mentally from that.
Oh, he's traumatized, all right.
Yeah, he's traumatized.
But
from
can-
that.
but can he
Probably he wants to put heat things about KFC, and he has every right to do so.
Well, we'll get to that, because you're talking about the content of his website. I'm talking about the domain name. Was your hand up?
Yeah, I mean, wouldn't it be, when KFC is a public company, isn't it a First Amendment right to be able to,
Well, there are First Amendment issues. What was your name?
Garrett?
Here, whenever, if you speak up, tell me your name. I like your names. Let's see.
Gillian.
Gillian, go.
Is it because he's not marketing anything under that name?
Right, right. So on the domain name, initially the judges would say, hold on, you're using the trademark, you can't do that. But Gillian's right, because if you go to a KFC Sucks domain name website, you know that's not sponsored by KFC. KFC is not going to put up that website. So there's no likelihood of consumer confusion, which is the ultimate trademark test, remember? Now, we get to the other points you guys were making. I think it was Simon and, I forgot your name in the back. Doesn't matter. Garrett? Thanks. So Simon and Garrett, now they're talking about the First Amendment right to complain. Okay? Is he allowed to say, I got all this harm from KFC? Absolutely, to a point. Okay? We have a right for freedom of speech in our country under the First Amendment. Our country is all about speech. But you can't hurt people if you're not telling the truth. There's the law of defamation and libel and slander. You've probably heard those words before. So if you say something on the internet or anywhere else that is false and you cause harm, you can be sued for that. So if everything you're saying up there is accurate, even though it says really bad things about KFC, no problem. But if it really was chicken and you called it rodent and their sales dropped off, you got a problem. Because KFC is coming after you. They might come after you even if you're telling the truth. So you have to think about who you're fighting with. You know, they're just not going to go down that easily. Yes, Nick.
So what happens in the case, like, just say it actually is rodent,
Yeah.
and they're just like, prove it. And we
Well,
have
that's
to, like,
right.
save a
That's
rat tail from the bucket or something.
Well, that's true. I mean, you know, cases, you have to have evidence. So if you eat the whole thing,
Okay.
bones and all, and there's nothing left, and you say, oh, by the way, I ate rat, and you've got no proof of it, you know, and you could put it on the web, but how do you prove it? But, you know, if you, like, take pictures and save it, and and 3 friends are there with you, and they corroborate your story, that's proof. Proof is important. I don't have much of a case without proof. Okay. Playboy is very litigious on the internet. Playboy is very jealous about guarding its trademark. It invests a lot in its mark. I mean, when you see these symbols, you know what it is, okay? And a lot of, you know, one reason we're sort of talking about adult content a little bit here is not because it's my interest, it's because the law is driven there when you deal with new technologies, okay? When still photography first came out, you know, what do you think were the first still pictures that were being sold? When video came out, internet websites, it's just a fact. That's where the money starts. And then it's, you have your Amazon, your eBay, and all the usual things. But this is usually where it begins. All right, now, who knows what a meta tag is? Anybody? So many people. Not one person knows what a meta tag is. Okay, a meta tag is, how do I explain this? You go to a website, and you see all kinds of words, right? There are some words that are embedded in the site that you don't see. Those are called meta tags. Why are they there? To get internet traffic. So for example, if you went to my webpage and you see a picture of me, a brief description of what I do. But I could put meta tags there that say, best lawyer in San Francisco, you know, justice, victories, whatever. And if you went on Google and you search best lawyer in San Francisco, it would be driven more to my page because I put that stuff in there. And you put some stuff in there, you know, that people don't see just to get traffic. All right, who's heard of Terry Wells? Hello, anybody? Who was alive in 1981? Okay. In 1981, the year after I graduated college, see, I'm getting old now. In 1981, Terry Wells was the Playboy Playmate of the Year. Fine, no problem. Terry Wells then leaves Playboy. She's allowed to do that. Terry Wells puts up her own website, terrywells.com. No problem there, right? That domain name doesn't have Playboy in it. It doesn't say terryplayboy.com. It's terrywells.com. Okay? What do you think is on the website? Terry Wells, yes. Take you out, Terry Wells naked, and?
So Playboy pictures? Like
No Playboy pictures. Who's in the back? What's your name again?
Rob, the Playboy icon.
No? Oh, wait. No. Well, you're anticipating it a little bit. We'll get there, kind of. Yes.
Maybe it's a former Playboy model, like, you know, saying that she was a Playboy before.
Oh, well, you guys are getting really close. You're like 2 steps ahead. So, good point. All right, so Casey, right?
Yeah.
So she's right. So if you went to terrywells.com, you'd see pictures of naked Terry, post Playboy. She's not using the Playboy pictures. And you'd also see Terry's friends. Terry then hires her own models, other naked women, not former Playboy bunnies, not current Playboy bunnies. Playboy doesn't have a monopoly on all naked people in the world. She doesn't use the Playboy people. So she's being smart, right? Nick, you got a comment? Meta- huh?
You've got like Playboy related meta tags.
Speak up, that's a good point.
You've got like meta tags related to Playboy. So that
Yeah, so that's the jackpot. So what she does that gets her into the attention of Playboy is, she has terrywells.com. She has her own naked ladies on the site. So far, so good. But she puts meta tags on her website. And they are Playboy, PMOY, Playmate of the Year, things like that. Playboy's trademarks in her meta tags. So, if any one of you, late at night and you're bored, you go to Google and you type in Playboy at the time, one of the relevant search results, of course, would be Playboy.com. That'll be the first one. But if you scroll down the page, maybe the fifth or sixth hit would be terrywells.com. And you go, huh, that's interesting, I'll click on that. And next thing you know, you like the women at terrywells.com better than at playboy.com, and then you start subscribing to their various offerings, and now you're paying money to terrywells.com because you typed in Playboy on Google, and those meta tags on her site using Playboy's trademarks took you there, and guess what? They're in competition. There is a likelihood of consumer confusion. This isn't the situation of Archie Comics and a baby, right? This isn't Madonna and a rehabilitation clinic. These are two websites designed to show you naked people and get money for it. Playboy is pissed off. I made their case, have I not? So what happens? A lawsuit, huh? Huh? They're going after Terry Wells big time, even though she was the 1981 Playmate of the Year, even though she made them a lot of money once upon a time. So it goes to court. And Terry Wells has to defend herself. Who here wants to represent Terry Wells, and what's your argument? Come on, this is your chance to be a lawyer. I'm only here once. Surprise me, amaze me, do something. Casey's up to the bat again.
Well, I mean, if she's not like using anything from Playboy, she's doing her own complete thing, she's completely separate, she's not saying like, she's not, downgrading Playboy or anything, she's just doing her own thing. There's no, kind of no harm, no foul, but.
Well, then, Playboy disagrees with that. I got some other hands. What's your name?
I'm John, sorry.
John?
It's almost like she's stating something on a resume, almost. It's like, okay, this is...
Say that loud, that's an important point.
It's almost like a point on a resume. It's like, okay, this is an accomplishment that I had. So...
That's exactly right. Okay, so let's just pause for a moment to reflect on her perfect answer. She is the 1981 Playboy Playmate of the Year. Just like when you guys graduate, hopefully you'll graduate, you can say you're a Sonoma State, 2015 graduate majoring in X. I can put on my resume, I graduated University of Michigan Law School in 1984. That's who she is, and that's what the judge ruled. She can actually use those marks because they identify her as to who she is. She's always the 1981 Playboy Playmate of the Year. Now, if you went to my webpage and I used Playboy meta tags, guess what? Am I allowed to do that? No, because I was not a Playboy Playmate. Are you surprised? Yes.
Related to this, 2 points actually. Can you sue for Google AdWords and hashtags?
Can you sue for Google AdWords and hashtags? I believe if there's true trademark infringement, you can sue in any context. Yes. Yes.
But since meta tags aren't like, I don't know, Terry, like at playboy.com or whatever, so it's not actually in the name of the thing, it's just kind of something underneath it or just a word within what you have said, then why would that be like infringement? Because it's just what Google searches, it's not like...
Right. What's your name again?
Daniel.
There you go. So that's an interesting point. I mean, the meta tags she used are not visible. So can there be trademark infringement?
Because
And that was an issue that had to be wrestled with, but the court basically said that it still has a practical effect.
mm,
Now, she had a good defense anyway, but that argument would not have worked. That, well, I'm scot-free because you can't see it. Let's keep moving ahead. I'm gonna skip that, because we have, this is a talk I normally give like an hour and a half. You're not gonna be here for an hour and a half. Okay, real quick. Who's received spam in their email inbox before, right? Do you know that like 99% of all emails are spam? Just nowadays, we have pretty effective spam filters, so you don't see most of the spam. The problem with filters, of course, every so often you get stuff that's still spam, and oftentimes legitimate emails get trapped and you don't see them. So you need to check your filters. Once upon a time, long ago and far away, when you guys were super young, there was no federal statute dealing with unsolicited commercial email, otherwise known as spam. And people were really upset because back then there weren't good filters, so literally in a given day you'd get like 150, 200 emails that were just garbage. And you'd have to sift through them, and it was a real pain. And people were getting upset, and they were bothering their politicians about it. So ultimately, 26 state legislatures passed different laws regulating how you send unsolicited commercial email, spam. What's the problem with having 26 different states regulating spam and having no federal law on board? What's your name?
Mila.
What is it?
Mila.
Mila, okay. What's the answer?
That the internet doesn't have state lines.
Right. The internet knows no boundaries. So I represented some internet marketing companies. And they would say, look, we're going to do this marketing campaign. And we have this email list of 2 million email addresses, right? And if one of those email addresses is johndoe@gmail.com, how do we know where John Doe is? Are we complying with the law of Arkansas, Hawaii, Tennessee, Alaska? What do you do? So I advise my clients, you should comply with the law of Delaware. Delaware, you say? Why?
They don't have any laws.
They don't have any laws.
Or like, internet laws. You can base it out of from Delaware sending it out, right?
That is a good answer, but not the correct answer. But I love the effort. These are not obvious answers for you guys. Let's have a new speaker. You made the mistake of looking at it. Do you have an answer? It's okay. You can still do this. I'll look at it too. All right. The answer is because Delaware had the most strict laws. If you got it wrong, according to Delaware law, you could actually go to jail. So if my clients abided by the law of Delaware, the most strict law, you were cool. Because if you comply with the hardest law, you're good anywhere. Ultimately, the federal government passed the Can-Spam Act of 2003, which pretty much made uniformity in the country. Of course, we're just a country. Emails go international, but that's a whole other subject. Behavioral advertising, or targeted advertising. Who knows what that is? You've all had it, but do you know what it is?
Isn't that what they do on Facebook?
Let's see.
Like whatever, like it's like what you talk about in messages and what you post about and stuff like that. You start seeing ads pop up on.
Yeah. So I say you say something on Facebook, or in the Gmail message like, God, I got a really crappy night's sleep last night, or I'm getting only 3 hours a night sleep because I'm studying so hard for these classes and a mistake. And next thing you know, these ads start popping up on the right. Are you having trouble sleeping? Please try Sominex, or go to this sleep clinic, or you need to meditate, or see a psychologist, or stop going to school, or whatever. Not the last one, of course. That's targeted behavioral advertising. These companies are watching what you're doing. You have what are called digital footprints. Okay? You're being profiled. Now, you might say, wow, that's really creepy. I hate that. That's a legitimate thought. You might, though, go on Amazon and purchase, like say you're really into hiking, and you buy a book about hiking, and then pretty soon, every time you go to Amazon, they're like, hey, have you considered these hiking books? Would you like to try this wilderness trail? We have recommendations on maps and whatever. And you're thinking, wow, this is really my sweet spot. That happens. I listen to audiobooks. They've kind of figured out what I like. and they propose books that I've never heard of, and 9 times out of 10, it's kind of creepy, but they're right. But you could also, buy something from Amazon. Say you buy a Mother's Day present for your mother, you buy her a book about gardening, and then you're getting inundated about tomato plants and tomato seeds, and you're like, I hate gardening, my mom likes it. So, long story short, the Federal Trade Commission has said, look, websites, if you're going to do profiling of people, if you're going to target them with ads, you need to disclose what information you're collecting from people, you have to tell them about it, and you have to give them choice so they can opt out. So in theory, if you guys actually read the terms and conditions on websites, you have some element of choice. When was the last time anybody in here actually read the terms and conditions that you click, I agree? Nobody, because it's written by boring lawyers, but it's there. Okay, I'm doing this quickly, that's good. Cybercrime. You guys are aware of cybercrime, it happens, right? It's happening every day. Here's an interesting question though. When can ordinary companies or people become responsible for the cybercrime of others? Yes.
When they hold personal information or, personal personal information?
Personal information can, if you don't handle personal information properly, there's all kinds of repercussions. And those are privacy issues, which we might have time to talk about. Well, let me just give you a hypothetical. I need somebody to be a disgruntled person on a mountaintop in Montana. Does anybody want to volunteer for that duty? This is another hypothetical. You're smiling. Are you on deck? You want to do that?
All right.
What's your name?
Adriana.
Adriana is like a computer genius. But she has this sort of anti-establishment mentality. So she's, in her mobile home on a mountaintop in Montana. She's like, you know what? I'm going to bring down a website just to show the world I can do it. So what big company do you want to crash on the internet? Pick a big one.
Goldman Sachs.
Tumblr maybe.
Tumblr? Okay, she wants to bring down Tumblr. So she's up on a mountaintop and she decides to launch a distributed denial of service attack, a DDoS attack, or DDoS. And that's what DDoS is. Back there. What's your name?
Evan.
Evan, talk to us.
It is a submission of a bunch of data or packets to servers at a company to bring down denial of information to bounce back, and then eventually it will flood the site and crash it.
Exactly right. Now you might not have been able to hear that. Did you hear that? Long story short, you're like launching this packets of information at a site to the point where the site crashes and just can't handle it. You were actually more complete than me. You were correct. So Adriana's done that. Well, she's about to do that to Tumblr, but she wants to be even smarter than that. She doesn't want to be caught, right, basically. So she decides to ricochet those attacks through another website back around and bring down Tumblr. So she ricochets it off what's called a zombie site. So what's your zombie website?
I'll say YouTube.
YouTube. Okay, great. These are big companies. So it happens. She launches, bounces off of YouTube, Tumblr crashes and is down for 24 hours, which is a lot of money for them. They want to be up and running. So the FBI is contacted. Unfortunately, as much as you tried, they find you, you go to jail. No longer are you in your little mobile home on the mountaintop in Montana. No longer do you have internet access. No more attacks for you. Bad, bad, bad. But Tumblr, that's fine. At least Tumblr knows they're not going to get attacked again by her. But Tumblr's still out $3.8 million for that crash. What are they going to do? Sue who? YouTube. What's your name?
Christina,
Christina's right. YouTube. Why YouTube?
because it's where it came, that's where she ricocheted it off.
That's where she ricocheted off. And what else about YouTube?
It's a big company.
Big company
So they
has
have
what?
money.
Has what they call deep pockets. They got money in their pocket, okay? You remember the lesson from earlier. You don't sue people that don't have any money. You sue big companies and they have a big deep pocket. So what's the argument? What's the legal theory? You probably won't know that. It's an ancient legal theory. Once I say it, you'll know it. Negligence. You guys have heard of negligence, right? What is negligence? If you cause harm to somebody when it is reasonably foreseeable and you're the main causal event in the chain. So the argument made by Tumblr is, hey, YouTube, it's foreseeable that these DDoS attacks happen, because they do happen now, it's not unheard of, and you were a causal link in the chain. You did not have sufficient, whatever, firewalls. I mean, all the terms you guys have heard of. I have a hand up over here. Yes.
They can't just say that it's foreseeable. They have to prove that, right?
Yeah, of course, they have to prove it. I mean, you can't just have an argument. You have to buttress it with facts and evidence. Now, YouTube's going to say, am I getting the company right? YouTube's going to say, well, there's foreseeability in general about these attacks, but there was nothing foreseeable about this attack, that Adriana on a mountaintop was going to ricochet this off of us and bring down Tumblr. And, you know, frankly, it's not our fault because, frankly, Tumblr should have protected itself. It's our job to protect our company and our people and our shareholders, and we shouldn't be protecting Tumblr. So I created this whole event for you, this legal event. It's coming to a courthouse near you soon, okay? This kind of case is going to happen. These are the things that plaintiffs' attorneys think of. They're like generating ideas, okay? How do we recover when there's loss? When companies suffer loss, they're always looking to shift the loss to somebody else. They go after insurance companies, go after other companies. It's in their interest. Unless the attorney's fees involved in the effort are going to outweigh the potential for winning, okay? You don't want to file specious lawsuits. You don't go suing the family Veronica, remember? That's a dumb lawsuit. Okay, I'm doing pretty well on time. We'll do a couple more. What time did we finish?
At 10 till. So
Oh,
that's,
it's 10?
7
All
minutes.
right, shoot. This is a pretty good story, though. All right, I'm going to do it anyway. All right, the question is, you know, has anybody here ever been an employee? Raise your hand if you've been an employee. You ever been an employer? Okay. Well, even if you've just been an employee, this is relevant. When do employers potentially become liable for the actions of their employees? So let's just say I'm teaching you, I've been invited here, and I walk out and there's a maintenance person who's been swabbing the deck, mopping the floor. There's a little sign saying wet floor, but he sloshes around way too much, and I come out and I fall and I break my back. In theory, I could have an argument against your school because I got hurt when this employee was doing work for the school in the ordinary course and scope of his employment duties. Got it? If I walk out and he starts beating me over the head with a metal-edged mop, first time he's ever done it, so the school's not aware that he has this proclivity, is the school responsible for his criminal conduct on me? No, it shouldn't be, because it's not part of his job duties to go beating the crap out of visiting teachers. He did it several times, and pretty soon the school's like, wait a minute, you're not paying attention, okay? This is a hypothetical. I've never been hit on the head by a mop. I've been teaching somewhere. So you get the basic framework. So once upon a time, this is a true story. There was a female employee attorney of a major law firm. She just graduated law school. She was working for a law firm. She went to a deposition where you go to a law office and there's a court reporter, you're taking testimony. So she's on the clock. And then she's leaving the deposition. She's driving home. She's talking on the phone. It's night. She hears a bump. Her car hits something. She thought she hit a deer. She proceeds home and she goes to sleep. And what is she awake to the next morning? Police at her door telling her she ran over and killed a 16-year-old girl. True story. The family, the parents of the 16-year-old girl, of course, are distraught. And once they get past being distraught, they're angry and they want justice, right? Because their daughter was taken away. And they want to get paid for the value of her life. And the value of a 16-year-old life can be quite high. There's a whole life ahead of this person. And believe it or not, in lawsuits, lives are actually valued. There are tables and actuarial, ways of looking at things. But believe it or not, a 16-year-old life is considered more valuable than an 82-year-old life in court. Or take a 30-year-old brain surgeon versus a 30-year-old unemployed person. They actually project what the income stream would be. And this was an educated family. This is a 16-year-old girl who was going places, and so it looked like she had a productive life ahead of her. But the family, yes, they could sue the young female attorney, but does she have deep pockets? No, she's got student loans. The law firm has a lot of money. So they sue the law firm under the ancient doctrine called respondeat superior. If you're acting in the course and scope of your duties as an employee, the employer is responsible. So, who wins this case? I have not given you all the facts. What, you guys have been asking, what's the proof, what are the facts? What else do you need to know in this situation that I haven't told you? Yes,
Sydney, and who was she talking to on the phone while she was driving?
what was the first part?
Oh, my
Oh, you're Sydney, okay, thank you, Sydney. Who is she talking to? Okay, she was on a work-related phone call. What else do you want to know, Jillian?
Why was the 16-year-old girl out in the middle of the road?
I have no idea. Why was the 16-year-old girl out in the middle of the road? To my knowledge, the 16-year-old girl was not ascribed any contributory negligence. That's, I don't know for sure. I forgot your name, I'm sorry.
Garrett,
Garrett,
why didn't you see the 16-year-old girl in the middle of the road?
I don't know. That's sort of related to the question I just got. I wish I knew that. What is your name?
Alex,
Alex.
and have she been working like long or late hours that would make her like predisposed to be drowsy or something?
Oh, was she being overworked so she'd be drowsy to the point of negligence? No, but it sort of relates to the prior point, and that is she was on the clock. She was on a work-related call, that was Sydney's question, right? Work-related call, and she was getting compensated for her time. That's how lawyers get paid. Let's see, is anybody else I haven't called them before? Oh, do you have a hand up? No? Yes, what's your name?
Morgan,
Yes, Margaret.
was she headed to a work event?
She was heading home from a work event, and I forgot your name in the back, I apologize.
Evan,
Yeah,
was she holding a phone or was she hands-free?
she was hands-free, that was not a problem.
Okay.
Your name again?
Rob,
Yes,
was she driving a company vehicle?
not a company vehicle. All right, so you kind of got the gist. Bottom line, she was at a work event. She was coming home from a work event. She was on a work-related call. She was being paid for the work-related call. I think the phone was actually provided to her by the law firm. The case settled. I don't know the exact amount because these things are usually confidential, but you can bet it was a lot of money. Contrast that to a situation where she's driving home. It's Saturday night. She's drunk. She's talking to her boyfriend. You know, has nothing to do with work. The law firm wouldn't pay a dime. So I have like, what, how many more minutes do I have? 2 minutes, okay. You have no privacy in the workplace, okay? I can tell you why. The bottom line, when you're employed, you have no privacy. So if you want to communicate, go out in the parking lot on your break and use your own private telephone. And use your own private email account, Gmail, whatever, okay? Don't do private stuff on your work phone, your work email, unless it's like really benign, like I'll be home at 6, or you know, please pick up the orange juice. Okay, can I tell one more story real quick? Okay, you talked about, you guys have been asking about the evidence. The evidence is critical. So in any kind of case, you need to find a smoking gun. I've represented a company, it's a middleware company, I would tell you what that is, but I don't have time. I've called Fundamental Software Inc. And they have a trademark in Fundamental Software Inc. And they've been Fundamental Software Inc. for 14 years in the Bay Area, based in Fremont. Along comes a new middleware company based in Denver. They come to a trade show and they say, we are Fundamental Software Inc. So imagine, a hamburger stand opening up across the street from McDonald's saying, we're McDonald's. Or Pepsi saying, we're Coca-Cola. So I write a letter to the attorney for the Denver Fundamental Software Inc. saying, welcome to the club, you're welcome to compete with us, but you can't have the same trademark name. He writes back and says, well, the names are kind of similar. No, actually I can. The names are kind of similar, but in this sophisticated space, consumers can tell the difference. There's no likelihood of consumer confusion. So I tell my client, unfortunately, these guys are obstinate. We're going to have to sue them. We file a lawsuit in federal court for trademark infringement, and then we're thinking we need the smoking gun. And the smoking gun was delivered to us by the senior partner of the law firm on the other side. And basically his problem was he was confused, and he sent his legal bills not to his Fundamental Software Inc. in Denver, but to my client in Fremont. So I got to write a letter. I was a very young attorney at the time. This guy, I will tell you so much more. It's a really fun story because he was really condescending to me. But I wrote him this letter saying, look, on your website it says you have the #1 intellectual property department in the world. And you're the chairman of that department. So you're the #1 IP attorney in the world. And you told me there's no likelihood of confusion. Yet you, the king of intellectual property, are so confused that you're sending your bills to my client because the companies have the identical names. With all due respect, you now need to surrender. Right? That is a smoking gun. Case ended immediately, and he was actually fired. By that client. So I think I finished.